prohibited from possessing any firearms or any weapons. While you're on bond, you will also be prohibited from driving unless you have a valid Texas driver's license. Okay. Now, I don't know why your license is suspended. I don't know if you know why your license may be suspended or invalid. But while it is, you cannot drive a motor vehicle. Do you understand, sir?
Yes, sir.
Now, these conditions of bond are going to remain until this case is over. I am going to ask you to sign these conditions of bond. You will be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you could be taken to custody. Now, you are going to need an attorney to represent you on this case. I do see that you have a case pending upstairs in the 262nd District Court. And I do see that you have an attorney representing you on that case. And that attorney is not appointed, right? Okay, so I'm going to require you to hire a lawyer on this case too. We're going to reschedule this case to allow you time to hire an attorney, okay? Now, if you do hire an attorney, sir, have that attorney contact this court before the next court date. You, sir, do not have to come back to court. You let your attorney take care of your case. However, if you do not have an attorney by the next court date, you will have to appear in court. All right, sir. Do you have any questions on anything that I mentioned to you, sir? All right, right behind you at the table, a pretrial officer, go with her, sign those conditions, have a seat, we'll reset your case. Millie, page 1, Corey Abram, THA. All right, let me see who else I have now.
Mr. Jackson's case was dismissed.
Oh, thank you. I don't know if he's still here.
I told Ms. Strauss that was going to happen. So.
I appreciate that. Thank you. I haven't got it yet, but as soon as I get it, I'll sign it. Okay. All right, I have another PC. Okay. Al-Halab Beya. Iman. Thank you. All right, sir. How do you pronounce your last name? Al-Habib? Al-Habib. All right, Mr. Habib. All right, so, and it's Aman?
Yeah, Aman.
All right, Aman, okay. And Ms. Kaufman, it's Alhabey. Okay. All right, sir, you don't have a lawyer today, right? All right, sir, I just wanted to inform you that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the assistant district attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you are being charged with. We're going to talk about any conditions of bond the court may impose, and then we're going to talk about an attorney. All right, Ms. Kaufman, whenever you're ready, you may proceed.
Yes, the officer was conducting surveillance on a parking lot known as a Sam's Club and observed the defendant conduct a rolling burnout, which is when the driver intentionally drags a burnout forward as the brake pedal is slowly released and the gas pedal is continuously accelerated to push the vehicle forward. So the rear tires are freely spinning from the ground, causing clouds of white smoke. When the defendant did this, he was 2 to 5 feet away from spectators or pedestrians recording these actions, and he dragged his vehicle approximately 15 to 20 feet.
All right, so the court's going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of reckless driving. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. So, Ms. Garcia, this is on page 2. You see, okay. So the court is going to order, sir, some conditions regarding your bond. The court's going to order that while you're on bond, you'll be prohibited from possessing any firearms or any weapons. And I see in my system that you're 20 years old. Is that right? All right. Because of your age, the court is also going to order that you do not consume or drink any alcohol or any controlled substance that you do not have a prescription for. No illegal drugs. These conditions of bond are going to remain until this case is over with. I'm going to ask you, sir, to sign these conditions of bond. You will be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. You are going to need an attorney, sir, to represent you on this case. Are you working right now, sir?
Yeah, just talking about for
Well, what type of work do you do?
forklift operator.
How long have you been doing that?
Well, it just barely started like last month.
Okay, no worries. Because you just started your job, do you want the court to appoint you a lawyer? Okay, I'll appoint you a lawyer this morning, sir. All right, sir, do you have any questions on anything that I mentioned to you, sir?
No.
All right, right behind you, the table. My preacher also go with her. Sounds conditions. Have a seat. We'll appoint you a lawyer. Millie, page 2. Do you see it? ALHA, court appoint. Dale Rouse.
Okay.
Okay, you checked in? I haven't checked out. No, let me call some other one. Yes, sir. Good morning. How are you? You need approach?
I'm good, Jim.
Okay.
You're on a felony case, you're on.
Oh, a family case. All right, now don't leave, Ms. Kaufman. I have some more.
Okay,
Sorry.
I won't leave, Your Honor. I'm sorry.
That's a problem. It's okay. I just want to explain what happened. You really did several games over the years. 18 hours a year. I know that we have released the whole computer because some of the
Millie, on page 6, do you expect Jill Francis to be here today?
They should be done.
Okay, because he has somebody that's on arraignment, the bond forfeited
Well, I'm gonna make.
the attorney record, so I don't know if he's going to be here or, okay, and if not, I can assign him another attorney.
Cindy.
Jose Morales, come up.
I'm in here. Okay, counter something, no, calm down, okay.
So when we probably restitution, so.
Well, I'm not gonna have her pay restitution to nobody.
Okay, I'm good for that.
Well, I'm not-
It is real though. I understand. That's nice.
She took.
All right, sir, good morning. You're Jose Morales?
Yes.
Mr. Morales, you don't have a lawyer today, right?
No,
All right, Mr. Morales, I just wanted to inform you of what you are being charged with. You are being charged with the offense of burglary of vehicles, of a motor vehicle. That is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. I see that this was an offense that was alleged to have occurred April 26th of this year. And I see that when this offense occurred, you were arrested on this charge. You did go to jail. You were released on a personal bond. I see that you went before a magistrate judge while you were at the jail, and I see that the magistrate judge issued some bond conditions, some conditions regarding your bond, which I have to believe you have a copy of. I want to remind you, sir, that is a court order. If you violate any of the conditions of that bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. Now, Mr. Morales, you're going to need an attorney to represent you on this case. There's 2 options regarding a lawyer. I can reschedule your case to allow you time to hire an attorney of your own choice, or would you like the court to appoint you an attorney this morning?
No, it's not. Shouldn't leave it there though. Okay, let me know if you need me to come up there for a recess.
Okay, do you want to hire him then? Is it I need to know if you're gonna, if you plan on hiring him, because if you are, we're gonna reschedule your case. So I need to know. If not, and if you want me to appoint you a lawyer, because it looks like you qualify for a court-appointed attorney. If you want me to appoint you a lawyer, I will this morning, so I just need to know.
Okay, so get a court-appointed lawyer, I get reset.
Maybe, I don't know, you have to talk to the lawyer.
Okay, well, I think that I'm gonna hire him.
All right, so then what we're gonna do is we're gonna reschedule your case. Now, since you're telling me that you're gonna hire him, I expect you to hire him, okay? So we're gonna reschedule your case to allow you time to hire an attorney. Now, Mr. Morales, if you do hire a lawyer, I'm sorry, I don't need the name, no. I don't need the name. I just want to mention, if you do hire a lawyer, it can be this lawyer or any other lawyer, okay? But if you do hire an attorney, just have that attorney contact this court before the next court date. You, sir, do not have to come back to court as long as you have an attorney representing you. However, if you do not have an attorney by the next court date, you will have to return to court. All right, sir, do you have any questions on anything that I mentioned to you, sir? All right, if you would just have a seat, we're going to reset your case, okay? Millie, page 11, Morales, THA. Oh, yeah, the guy that was, that didn't answer, just don't worry about it. We'll call him back later. Who's that?
Because there's so much going on today.
Oh, yeah?
Sure.
Okay. Alberto Calixto. And Ms. Kaufman, I need you on this one.
Yes, and I'm filing it right now.
Look at this.
No, actually, let me just take a photo, not upload it.
Ms. Garcia, this is on page 3, Calixto. Thank you. And Ms. Kaufman, this is a piece, probable cause for Calixto, Calixto, last name. All right, so you're Albert Calixto?
Yes, sir.
Mr. Calixto, you don't have a lawyer today, right? All right, Mr. Calixto, I just wanted to inform you that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the Assistant District Attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you're being charged with. We're going to talk about any conditions of bond the court may impose, and then we're going to talk about an attorney. All right, Ms. Kaufman, whenever you're ready, you may proceed.
Okay, the officer drove up on a vehicle crash at the intersection of Wheatley Street and West Tidwell. The defendant's vehicle had struck a Nissan Altima, and the defendant began running on foot until the witness of the crash chased him and held him until police arrived. The witness stated to officers that the defendant was running away from the crash.
All right, Mr. Calixto, the court's going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of failure to stop and give information. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. So what we're going to do this morning, sir, is the court's going to order some conditions regarding your bond. So, Mr. Calixto, I see here that you're 18, is that right?
Yes.
All right, Mr. Calixto, the court's going to order that while you're on bond, you will be prohibited from possessing any firearms or any weapons. While you're on bond, you will also be prohibited because of your age from drinking any alcohol or any controlled substance that you do not have a prescription for. And while you're on bond, you'll be prohibited from having any contact with the individual that's accusing you of this offense. That person is an Ashley Patel. I have to believe you don't know who that is, right? So have no contact. And Ms. Garcia, I don't know if you see the intro. Okay, no contact with the complaining witness. Mr. So these conditions of bond are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. Now, you're going to need an attorney to represent you on this case. Are you in school?
Yes.
What school are you going to?
And your choice.
And what grade are you in?
Junior.
Junior, okay. All right, so do you want the court to appoint you a lawyer today, an attorney to represent you on this case?
Yes, sir.
All right, I will appoint you a lawyer this morning, sir. All right, Mr. Calixto, do you have any questions on anything that I mentioned to you? All right, right behind you at the tables, my preacher also go with her, signs conditions, have a seat, I'll appoint you a lawyer. Millie,
Yes, sir.
page 3, Albert Calixto, court appoint. Okay. Do you normally work upstairs in district court?
I am in public integrity.
Oh, public integrity, okay.
Yes, so I am one of the people who does not have an assigned court, so that's why I'm able to come help out.
Okay. Well, Fridays is our busiest day. Those
I
are
know.
all probable cause.
I
Where I need to,
It's keeping me young.
that's okay. Well, I'm having another one, and you can talk to Mr. Bone while we're standing here, it's okay. Jesus Valadez. So, Ms. Kaufman, this is another PC that I need to hear on Valadez. All right, so you are Jesus Valadez?
Yes, sir.
Mr. Valadez, you don't have a lawyer today, right?
I signed up for one, but
No? Well, that doesn't mean that you have one, so you don't have a lawyer today then. All right, Mr. Valadez, I just wanted to inform you that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the assistant district attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we'll talk about what you're being charged with. We'll talk about any conditions the bond the court may impose, and then we'll talk about an attorney. And Ms. Garcia, this is on page 14, Valadez. And do you have this up, Ms. Kaufman?
Yes, I
All right, let me hear PC.
Officer was conducting surveillance on a group of car owners known to conduct hostile street takeovers in city intersections. Plainclothes deputies observed the movement and actions of the group and communicated to other units about defendant's vehicle doing 6 to 7 donuts in a pit of around 8 to 10 vehicles and getting within 10 to 15 feet of striking vehicles. They conducted a traffic stop and observed a black Glock caliber or 9mm caliber pistol in the glove compartment of the blue Dodge Challenger, which was not in a holster, but I'm trying to see how it's pled, Your Honor.
I'm looking at the charging instrument and says Jesus Valadez on or about April 25th, 2025, they then and there intentionally knowingly carry on or about the defendant's person a handgun in a motor vehicle under the control of the defendant. The defendant was engaged in criminal activity other than a Class C misdemeanor that is a violation of the law or ordinance regulating traffic, namely evading arrest in a motor vehicle. And that was not true, right?
That is correct, Your Honor.
Okay, well, since that is not the correct charging instrument, then I'm going to find no probable cause. So, Mr. Valadez, I'm going to have to let you know that you're very fortunate. Very fortunate. The court is going to find that there does not exist a sufficient probable cause to continue with your case. Because the court is finding that there does not exist probable cause, then you are, sir, discharged, and sir, you are free to go. You're free to go. All right? Just be careful. Thank you. And I don't know what you normally do.
I will.
Oh, thank you.
I won't take it to grand jury.
Okay. Yeah, they want to hear these cases, don't they?
Huh?
I said they want to hear these cases,
I
don't
know.
they? Okay. All right, so let me see. I'll see who the next one is now. Okay, next person for public cause. Let's see. John Carper. So, Ms. Kaufman, his last name is Carper, Carper. All right, so you are John Carper? Yes. Mr. Carper, you don't have a lawyer today, right? I'm Ms. Carper.
All right, you ready? Let's roll, nerds. Come on, you ready? Please.
Is approaching on page 18 and 19. Smith, come on
Good
up.
morning, Mr. Coyne. Good morning. Happy Friday.
That's Judge Aaron Smith is on
Okay.
the docket.
Come up, Ms. Smith. Good morning, Cole.
Good morning, Judge. How are you?
Here we go. All right. Good morning, Ms. Smith. Ma'am, you're charged with two cases. You're charged with assault of a family member. You're also charged with a garden variety assault. Both of those are Class A misdemeanors. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Thank you, Your Honor. On April 26, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. The officer interviewed the complaining witness on scene and found that the defendant observed the second complaining witness, another woman, and complaining witness one, her boyfriend, open the apartment door. The defendant attacked complaining witness one, leaving visible scratch marks on her chest, shoulder, and hand. The defendant then yelled at complaining witness two, a stranger who tried to hide in a closet, when the defendant followed her and slammed the door on her toe, causing pain and her toenail to come off. The defendant then went downstairs and smashed complaining witness one's front windshield.
So we have, I guess, the girlfriend and then just an unknown person.
Yes, Your Honor.
Okay. Ms. Smith, I'm going to find that there's sufficient probable cause to go forward with the cases. I'm now ordering you as a condition of your bond not to have any contact with either of the complaining witnesses and not to be in possession of any weapons. Do you understand?
Yes.
If I find that you violate these conditions, if I find that you pick up any new cases, I will revoke your bond, put you in jail. No more PR bonds. You understand?
Yes.
Let me see if there's a protective order that's been issued. There is a protective order that's been issued on the 27th of last month. I would get to know it. If you do something to violate the protective order, the state can and probably will file additional cases against you. Violation of protective order. It's one of the worst cases you can pick up. So know what you can and can't do. You've got a great lawyer here. Listen to him and he will take care of you. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him and he'll tell you if and when you have to come back to court. For now, we will have you go to Victoria, sign a reset. You will then take a seat in the jury box while we get your bond conditions. We'll have you sign it and then you'll be free to go.
Thank you, Your
Thanks,
Honor.
guys. So can you file
Right this way.
no contact, no weapons on both of the cases, please?
Judge, next is page 13. Martinez, come on up. Okay, go ahead and sign.
Morning, Judge.
Mr. Butler,
Like you're ready to deal some cards.
that's right. Always a pleasure. How are you, man? So you are Miss Martinez. Miss Martinez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, man. Okay.
Thank you, Judge. On April 26, 2025, a law enforcement officer observed a motor vehicle fail to slow down as it crossed train tracks, causing all four tires to come off the ground and the vehicle to go airborne. The law enforcement officer observed the motor vehicle land lose control, and nearly crash. A traffic stop was conducted. The law enforcement officer contacted the driver and the sole occupant of the motor vehicle, who he observed to have glossy eyes and a strong odor of alcoholic beverage emitting from her breath. The defendant stated she was just at a bar called the Sugar Room. The defendant stated she had 3 alcoholic beverages. The defendant stated she had chronic back pain, but was willing to perform the standard field sobriety tests. A 6 out of 6 was recorded on the HGM, a 4 out of 8 on the walk and turn, a 3 out of 4 on the one-leg stand. The law enforcement officer observed a receipt in the defendant's purse showing she had purchased 8 alcoholic beverages throughout the night. The defendant refused breath. A blood warrant was signed and executed.
Okay. Any prior DWI? Okay.
So, Your Honor, there's no traffic offense stated. He claims that the car went airborne, all dukes of hazard,
Sure.
yet there's no evidence to support that. I mean, did all wheels come off?
This is a probable cause hearing, right? We're not going to get evidence at this point, you know. I think that there's sufficient probable cause to go forward. Now, it doesn't mean you're guilty, but it's enough to go forward for now. Ms. Martinez, I am going to find that there's sufficient probable cause, and I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, we will revoke your bond, put you in jail, no more PR. You understand? Because you have a lawyer, we will waive your appearance. You don't need to waste your time coming to court, but you must stay in touch with Mr. Butler, and he'll tell you when you have to come back to court. For now, we'll have you go to Victoria Center Reset. We'll have you take a seat in the jury box while you get to pretrial services, sign your documents, and then you.
All right, appreciate it.
Counsel, was it Marshall?
Yes,
All right, Judge, next is
Hi.
page 12. Marshall, come on up.
may I approach this?
Please.
All right.
Good morning.
Hi, good morning. How are you?
I'm all right. Hope you're
Happy
doing
Friday.
well.
Good morning, Mr. Marshall. Good morning.
Good morning.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 25th, 2025, in Harris County, Texas, a law enforcement officer conducted a traffic stop on a vehicle going 58 in a 40-mile-per-hour zone. The law enforcement officer made contact with the defendant driver and could see in plain view a pistol and a bag of marijuana next to the defendant. The law enforcement officer detained the defendant and found another bag of marijuana in the defendant's jacket pocket.
Okay. Mr. Marshall, I'm going to find that there's probable cause to go forward with the case. While this case is open, I'm ordering you not to be in possession of weapons. Do you understand? If I find that you do, if you become a danger to my city, it's not going to go well for you. You just had a case dismissed not a month and a half ago, and now you're here again. Don't be a danger to my city. Do you understand? Yes or no?
Yes, sir.
Because you have a lawyer, we will waive your appearance, but you must stay in touch with him and he will tell you if and when you have to come back to court. Don't pick up any new cases. Can you, does he have a, you said he was driving, right?
Yes, Your Honor.
Can you run him? Does he have a license?
Yes, I'll run it right now.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You must maintain car insurance. That is also a condition of your bond. If I find that you're driving without either, likewise, I will arrest you, put you in jail. You understand, sir?
Yes, sir.
Judge's license is eligible.
Wonderful. So we'll have you go sign a reset now. We're going to have bond conditions created for you to sign. Once you sign it, after that, you'll be free to go. So we'll just have you wait in the jury box.
Yeah, I have excuse.
All right, Judge, next is page 2 and 3. Carlo, come on up.
All right.
All right, then have a seat in the jury box behind you.
Good morning, Mr. Barlow. Good morning. So you're charged with 2 cases. You're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You're facing a year in jail and or a $4,000 fine. Likewise, on the gun case, you're also facing a year. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Okay.
Thank you, Your Honor. On May 30th, 2023, an officer was dispatched to an auto accident in Harris County, Texas. A wheel witness on scene advised that they observed the defendant to exit the vehicle and enter the back seat. The defendant, the sole occupant of the vehicle, was asleep in the back seat of the vehicle with the keys in his pants pocket. The officer requested the defendant to exit the vehicle, to which he was observed to have heavily slurred speech, glossy red bloodshot eyes, and unsteady balance upon standing on his feet. The defendant stated he was drinking with friends at a party and arrived in his own vehicle and left on his own. He was unable to perform standard field sobriety tests safely or follow the officer's instructions due to him continuously falling asleep and vomiting. The DIC was read, and he was unable to deny or give consent to breath or blood due to his level of intoxication. A blood warrant was then obtained and executed. While conducting an inventory of the vehicle incident to arrest, a black handgun was observed in plain view on the driver's side panel. The blood alcohol level came back to a 0.187.
Mr. Barlow, I'm going to find that there's sufficient probable cause to go forward with the case. I don't know if you have a problem with drugs or alcohol. Now is the time for you to address it if you do. I'm ordering you not to use, and if I find that you do, if you have a problem, you don't address it, I'm going to do it for you, and I promise you're not going to like the way that I do it. Do you understand? You are not to use alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you like crazy to make sure you're not using. Do you understand?
Sir.
You're also, while on bond for this case, not to be in possession of any weapons as well. For now, any prior DWIs, and does he have a license? Please.
Judge, I'm not seeing any prior DWIs here.
Okay. As with every case, you are not to drive unless you have a valid license and insurance in your name. You must maintain car insurance as well.
His license is over.
Okay, so for now, we're going to have to go to Victoria Center and reset. You will eventually get with Roxanne for your bond conditions. After that, you're free to go. Thank you.
All right, Judge, bottom of page 1, Alborno, right?
No more lawyers?
Not at this moment, Judge. Ms. Martinez?
Good morning, Mr. Albornoz.
Good morning.
Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On August 23rd, 2023, an officer responded to a disturbance/unknown weapon call on Hillcroft Drive in Harris County, Texas. The complaining witness and the defendant were dating and living together, but they recently ended the relationship. On this day, they had a verbal disagreement, and the defendant called her a stupid bitch and a stupid hoe for smoking one of his cigarettes. The complaining witness advised that the defendant kept getting closer to her, so she pushed him away, at which point the defendant slapped her in the face with an open hand and punched her in the face with a closed fist, causing her to have a black eye. The complaining witness advised the defendant, then punched her in the right arm, causing severe visible bruising, dragged her from the living room by her shirt, and kicked her multiple times while she was on the floor. The complaining witness advised the defendant continued by punching her in the ribs and thighs multiple times. The defendant then banged her head against the wall, causing blood from her nose to splatter against the wall. The complaining witness advised the assault caused her pain. The defendant then smashed her phone and prescription glasses against the bedroom door, breaking both items. The complaining witness advised that during the assault, while the defendant was banging her head against the walls, the defendant pushed her so hard that large holes in the living room, hallway, and bedroom walls formed. The officer took pictures of injuries and of the damage.
I want you to know that I'm going to protect every single person, every single thing in my county at all costs. And if I find that you're a danger, I'm going to put you in jail and make your bond so high you'll have patches of hair falling out. Do you understand?
Sir.
You are not to have any contact with the complaining witness in this case. You are not to consume alcohol, illegal drugs, and I'm going to test you like crazy to make sure you're not used. Do you understand? There is a protective order that has been issued in this case. Know every single part of it, because if you violate any of the set conditions, the state can and will file a violation protective order, and that is the capital murder of misdemeanors. You violate conditions on one of those, I can have a hearing to hold you at no bond. Zero bond until this case is over with. And I will do it in a heartbeat to protect my city. Do you understand? What are you doing with yourself these days?
I'm working,
Are you working full time?
sir.
Yes, you know. It's okay. I want to see what he's doing. You need to understand something, Mr. Albornoz. If I revoke your bond and make it 5, 10, 15,000, and you don't have anyone to bond you out, you will be stuck like Chuck in there until this thing is over with. Do you understand? So don't be a danger to my city. I'm going to have you sign a reset with Victoria. You will eventually get with Roxanne for your pretrial conditions, then we'll take a look at your affidavit. Don't worry about conditions, Cole, because I'm going to monitor him and make sure he's not using.
Next judge is page 2.
Yeah.
Avila,
I'm going to make sure he's working.
Diaz,
We need to.
oh, for Avila,
Yeah, I think it's fine.
You said Vic Diaz, you said?
Avila.
page 2,
Avila.
top of 2. Ben?
All right.
Oh, okay.
Fine, no.
Page 4, Bobo,
You were Mr. Bobo.
Good day.
So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On October 6, 2024, in Harris County, Texas, officers responded to an assault call. The officer met with the complaining witness who stated that her and the defendant had been dating for 2 years. The complaining witness stated that they got into an argument where the complaining witness attempted to gather her belongings, but the defendant hid her luggage. When the complaining witness tried to get her belongings, the defendant struck the complaining witness in the head 10 to 15 times, causing pain. The law enforcement officer observed the video footage showing the complaining witness get struck by the defendant.
Find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness in this case. Is there no protective order that has been issued in here?
I'm just checking.
One is the image, but let me see if I can find an intro comment. One has been signed intro.
Okay. I'm going to deny that. Mr. Bobo, I'm going to enter in what's called a matrix order for emergency protection. This is a court order that identifies Ms. Nelson as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this, the state can and will file additional charges against you, a violation of protective order. It's one of the worst cases you can pick up. I am ordering you while this case is open, not to have any contact with her whatsoever, and not to be in possession of weapons.
Yes, sir.
Do you mind filing that, please? No contact and no weapons.
Yes, sir.
We're going to have you come up here, sign the order for protection. After that, I'm going to get you to Victoria. We will have you sign a reset. After that, I'm going to have you take a seat in the jury box. So we'll get additional bond conditions. Once you sign that, you'll be free to go, and please have a lawyer, sir.
Yes, sir.
Come on.
All right, Judge, next is page 4 and 5. Bustamante, come on up.
Good morning, Mr. Bustamante. You speak English, sir?
Sir.
So you're charged with terroristic threat of a family or a household member. That allegation kicks it up to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. Oh. Oh. He's on bond for a terroristic threat, and he's picked up another terroristic threat.
Correct, Your Honor.
They're my kids. My kids.
We are going to do a probable cause on the new case. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
We'll do probably, obviously do probable cause rating. There's some other things we want to get into when we actually have a lawyer appointed. But we're happy to do the probable cause rating right now.
Is it part of the new case or the old case? Okay.
And the old case.
You have the right to remain silent. Exercise that right. Now is not the time for you to fight this case, Mr. Bustamante. Please.
Judge, on April 25th, 2025 in Harris County, Texas, law enforcement officer dispatched to a criminal mischief call and made contact with the complaining witness, defendant's son, who stated that the defendant damaged complaining witness's mother's vehicle. That would be the defendant's wife's vehicle. And when complaining witness asked the defendant why he did it, the defendant replied, "I'm going to beat your fucking ass." Complaining witness stated he was in fear for his life due to the defendant being known to be aggressive with family members.
Same complaining witnesses in the first case?
Yes, Your Honor. The complaining witness in the first case is the defendant's daughter. The complaining witness in the second case is the defendant's son.
Mr. Bustamante, I'm going to find that there's sufficient probable cause to go forward with your case on the new case. I ordered you not to pick up any new cases. I told you not to become a danger to my city. You've now picked up a new case, endangering my city. I now am going to revoke your bond. You go into custody. Goes with you.
What in the world is a 16-year-old?
Stop. I will appoint you a lawyer today if you don't have one, but.
He threatened me to kill me.
Yes, thank you.
Then they put me with murders. They threatened me inside of jail? What is that right?
Yeah. He was on the land. He was on the land anyways, right? So it was at 25 more.
Yeah, it's not.
All right. So 5,002. Did he get a PR bond on the first case? Yeah. On the second
It
case?
was the PR bond, then a surety.
On the new case, it's a surety?
On the old case, it was a surety.
Yeah, the old case, yeah, who made sure.
Next.
Okay, sure. So.
Okay.
All right, Judge, next is page 5, 6, Eller. Eller. Okay, come on up, please.
All right, good morning, Mr. Ayler. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. It looks like you're also charged with unlawful carrying of a weapon. On that one, you're facing up to a year and or a $4,000 fine. Okay.
Thank you, Your Honor. On April 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling 50 miles per hour in a 30-mile-per-hour zone via radar and failed to signal at a right turn. A traffic stop was initiated, and upon contact with the defendant, the law enforcement officer observed a handgun on the rear right passenger floorboard, unholstered and later confirmed to be loaded. Law enforcement officer observed glossy eyes, strong odor of alcoholic beverage, and slurred speech from the defendant. The defendant admitted to consuming 3 alcoholic beverages. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, and a 2 out of 4 on the one-leg stand. The defendant consented to provide breath and blew a .136 and a .141.
Okay. Any prior DWIs?
Yes, Your Honor, out of a different county.
Is it open?
No, Your Honor, it was closed in 2014 with 12 months of probation.
Can you run a full NCIC to see how many there are?
Yes, Judge.
Mr. Ayler, I'm going to find that there's sufficient probable cause to go forward with the case. Also, if you can run his license, please. I'm now placing a restriction on you, Mr. Ayler. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. No more PR bonds. Likewise, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. I'm sending notice to DPS in Austin. Every single officer in the state will know that if you're driving a vehicle and it doesn't have an interlock, you will be arrested and put into jail. Do you understand?
Judge, it's just the one previous DWI.
Okay, license, would you say?
License.
You're also not allowed to drive unless you have a valid license and liability insurance in your name as well. That is a part of your bond conditions. For now, I'm going to have you go to Victoria, sign a reset. You will eventually get with Roxanne for your bond conditions, and after that, you'll be free to go.
It is other.
Great. Okay, come on,
CHA?
please.
Okay. Counsel, are you ready on go down? Yes.
Hi.
Judge, next.
Great to see you.
Great to see you as well. Go down, come on up.
Okay.
Good morning, Mr. Godine.
You doing, sir?
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Thank you, Your Honor. On April 26, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle run a red light and initiated a traffic stop. The law enforcement officer made contact with the defendant, the driver, and observed bloodshot eyes, droopy eyelids, constricted pupils, unbalanced, and the defendant to be talkative and have trouble concentrating. The defendant admitted to running the red light. Standard field sobriety tests were conducted. A 2 out of 6 was reported on the HGN, a 5 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The defendant estimated 30 seconds passing in what was in reality 72 seconds on the one-leg stand. The defendant admitted to smoking weed earlier. The defendant consented to breath and blew a .00. The defendant consented to drug influence evaluation, and a drug recognition expert believed the defendant to be under the influence of a central nervous system stimulant, a narcotic, an analgesic, and cannabis. Thank you, Your Honor. And the defendant admitted he took oxycodone or narcos and smoked weed. A blood warrant was obtained and executed.
Mr. Godin, I'm going to find that there's sufficient probable cause to go forward to the case. If you have a drug or alcohol problem, now is the time for you to address it. I'm giving you the opportunity now. If I find it becomes a problem while you're on bond, I'm going to revoke your bond. I will put you in jail, and I'm going to address it myself. Oxy is one of the absolute worst things that you could possibly take because you build up such a tolerance to it. You literally put your lungs to sleep if you take too much and you end up dying. I cannot tell you how many people have died from this drug. It's absolutely disgusting. And the maker has been sued repeatedly by how many different states in this country because it's such an addictive thing. Don't use. I'm telling you now, within the next week, I'm going to test you because I want to make sure you're not using. Do you understand?
Sir.
Don't use. You've got a great lawyer here. She will take care of you, but I don't care who you have here. Jesus, you use. It's not going to go well. Do you understand?
Yes, sir.
License, prior DWIs?
The license is eligible.
Okay.
And not seeing any prior DWIs here, Your Honor.
I'm telling you that I've had probably a handful of friends that have died from Oxy because they continue to take it, build up that tolerance and put their lungs to sleep. It's disgusting. Just don't. Do you understand?
Yes, sir.
I don't want you to kill yourself. Life is way too short.
Yes, sir.
You're not allowed to drive unless you also have a valid Texas driver license and liability insurance. Do you understand? Because you have a lawyer, we will waive your appearance, but it is your responsibility to stay in touch with Ms. Barks, and she'll tell you if and when you have to come back to court. Be careful. Don't use. As long as you do, all is well. Come on. Thank you, Ms. Barks.
This way. All right, Judge, next is, go ahead and sign, please. Page 6. Garza, come on up.
Hey, Lori. You want to chat me what you want, what you got? Good morning, Mr. Garza.
Good morning.
Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 24th, 2025, in Harris County, Texas, an undercover law enforcement officer observed a vehicle conducting multiple donuts in a parking lot in close proximity to other vehicles and pedestrians. The law enforcement officer maintained visual of the vehicle until another law enforcement officer was able to conduct a traffic stop of the vehicle and detain the defendant. The defendant admitted he was the one driving the vehicle and doing donuts.
Mr. Garza, I'm going to find that there's probable cause to go forward with the case. Does he have a license?
It is eligible, Your Honor.
Okay, I'm ordering you now as a condition of your bond not to participate in these types of activities anymore. Racing, street takeovers, donuts, reckless driving. If I find that you do, first I'm going to put you in jail. The next thing I will take your ability to drive away. Do you understand?
Yes, sir.
How old are you, sir?
17.
You want a court-appointed lawyer?
So what's up?
You need a lawyer to represent. Do you know if your family's going to hire you one, or do you want to apply? Okay, so you don't want to apply for a court-appointed lawyer. Okay. I'm going to have you go to Victoria, sign and reset. We'll have you take a seat in the jury box while I get your bond conditions. Don't drive maniacally. Do you understand? You are also not allowed to drive unless you have car insurance in your name as well. If I find that you do and without it, it's not going to go well.
Yes, sir.
Come on. Come on.
Barlow.
So just,
If not signed.
well, so I guess
I can just go on with it. So you can take
Say
Brad.
wishes to hire a lawyer so that we don't, so we
Okay.
No, he's going on. Oh, okay, okay.
Next judge is,
Hey, John, can you answer an email from Lori regarding a Holman, please?
Yes, Judge.
Thanks.
page 15, Ramirez, come on up.
Oh, and can you file those conditions on me?
Yes, Your Honor. I have some more permission here. Keep going.
Okay.
This is a.
Okay, it's signed on both of them.
Okay. Speedo Bobo, come on up.
All right, good morning, Mr. Ramirez.
Good morning, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do the probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 27, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a major accident. The law enforcement officer observed a house with damage to the garage and the front of the house. Additionally, a Harris County Constable patrol vehicle was parked in front of another home and was damaged. The law enforcement officer observed the defendant's motor vehicle to have damage as well. The law enforcement officer observed the defendant to match the description given by dispatch and detained the defendant. The law enforcement officer met with a witness who recorded the accident and spotted the defendant as the driver. The law enforcement officer ID'd the defendant by his Texas driver's license. The law enforcement officer observed a strong odor of alcoholic beverage emitting from the defendant's breath, red bloodshot eyes, and slurred speech. The defendant declined to perform standard field sobriety tests. The DIC was read and the defendant agreed to provide a sample. However, due to the defendant's age, the law enforcement officer obtained a blood warrant, which was then executed.
Any prior DWIs?
No, Judge.
License?
License.
Okay, Mr. Ramirez, I'm going to find if there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not going to go well for you. I will revoke your bond, put you in jail. You understand?
Yes, sir.
If you become a danger to my city, I'm going to do everything in my power to protect it. You're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name.
Yes, sir.
How old are you, sir?
18.
Do you have the ability to hire a lawyer?
Might possibly, yes, sir. Not sure. I did just apply to appoint one.
Are you working? What do you do with yourself?
Yes, sir. I do work. I'm an employed full-time cashier at Bunsa within Katy, but the money.
Don't. I just want to know if you're working.
Oh, yes, sir.
All right, good job. So I'm going to appoint your lawyer today.
Thanks, sir.
Don't use. I don't care where you're going, what you're doing. I don't care if it's Jesus asked you to break bread. Don't use. It's not going to go well. Do you understand?
Yes, sir.
All right. I'm going to have you sign a receipt with Victoria. We'll have you take your seat in the jury box while we have you sign conditions and find your lawyer.
Okay, thanks, sir.
All right, Judge, next is page 15, Randolph. Come on up.
Back off.
Good morning, Mr. Randolph.
Good morning.
So you're charged with assault, causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
The judge. Judge on.
We're doing, here, there's no reason for you to be looking out there. We're going to do probable cause. We have to find out what happened with the case.
Judge, on April 23rd, 2025, an officer dispatched an assault call and made contact with the complaining witness, and the defendant. The complaining witness stated that he saw the defendant talking to and following a witness, and the witness then started to run away and observed the defendant to chase after the witness. The complaining witness then got in between the defendant and the complaining witness, and the defendant then struck the complaining witness with a closed fist. The complaining witness said he felt pain, and they grabbed the defendant and they proceeded to grapple until security arrived. The witness stated that she did not know the defendant and that her and her friend walked past the defendant on the street. The defendant then began to verbally harass them and started to get verbally aggressive. She asked the defendant to leave them alone, and the defendant continued to refuse to do so, and that she began to walk away and to try and get away from the defendant, but got stuck at the intersection crosswalk. Then corroborated the facts that the complaining witness provided about getting between the two of them.
Mr. Randolph, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? I'm ordering you also now not to be in possession of any weapons, not to have any contact with the complaining witness, and not to go to this part of the street. Do you understand?
Yeah.
Don't be a danger to my city, man. I'm not asking for much.
I'm not in danger. I do never know these people, Your Honor. I need a public defender.
I'll give you one. But I'm telling you now, Mr. Randolph, don't be a danger to my city.
I was never in danger. Just I don't intend to be in danger either.
All I want my streets safe.
It was in danger to me, and that's why I'm showing up today.
I'm going to protect my streets at all costs. You
Can
understand?
you protect me from these kind of people?
I'm going to have you go to Victoria, sign a reset. After that, I'm
I
going
do
to
need a public defending office, your judge or
I already
lawyer.
told you I was going to give you one. Just really.
I'm really scared for my life because I just did 4 years and I'm going through the same thing again in your courtroom when I did good and I'm going through all the facilities. There was never in a harm's way standing 100 feet away from these people or 200 feet. I was never 100 feet within there.
No. Exercise.
And I'm
the right
running from
to
these
stop.
people.
You're going to say something that hurts your case. Just stop.
Yes, sir.
I'm not asking you to say anything. I just want
to also be safe in your community also.
don't use any dope. Don't use any alcohol.
Never was. I was sober that day. I was sober as can be, no drugs, nothing. Enjoying a beautiful day for my mama's funeral. I don't know these people.
Listen, I'm gonna have you sign a reset. I'm gonna have you take your seat in the jury. Yo, I'm not talking to you. Once you sign the reset, just take a seat in the jury box. I'm gonna find your lawyer, but we need you to sign conditions. Don't leave until you sign the bond conditions.
Yeah.
Come on.
All right, the next is page 16. Reed, come on up.
Hey guys, State, you're gonna have to give her the location on the street so that she knows. All right, good morning, Miss Reed.
Good morning.
Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 26, 2025, a law enforcement officer was dispatched to a Target store in reference to a shoplifter in Harris County, Texas. The law enforcement officer spoke with the complaining witness, the loss prevention officer, who stated that the defendant was observed on videotape obtaining items without payment. The defendant was observed on camera grabbing multiple items of merchandise, placing them in her backpack, and bypassing all points of sale without attempting to pay for the items. The complaining witness stopped the defendant after they had passed all points of sale, and the defendant was ID'd by name and date of birth. The total value of the items taken was $119.97.
The co-defendant?
Let me check.
Mr. Reed, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go to any target for any reason. Do you understand?
Yes, sir.
If I find that you do, I will revoke your bond, put you in jail. No more PR bonds. Likewise, don't pick up any new cases. Do you have the ability to hire a lawyer, ma'am? Okay, we can have you fill. Did she fill one out?
Yes, Jay Reed?
Okay, you're currently in school?
Yes, sir.
Are you in school full-time?
Yes.
Okay, I'm going to appoint you a lawyer, ma'am. If you want to go to Victoria, we'll have you sign a reset. After that, we'll have you take you sit in the jury box while we find you a lawyer, and then we'll have you sign bond conditions as well, ma'am. Thanks. So no going to any target, please.
Yes, Your Honor. And there are no co-defendants to my knowledge.
All right, Judge, the next is page 17, Reyes, come on up.
Good morning, Ms. Reyes. You were charged with driving while intoxicated. You're facing up to 6 months in jail and a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. The right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 25th, 2025, a law enforcement officer was dispatched regarding a DWI investigation in Harris County, Texas. The law enforcement officer who conducted the traffic stop stated he observed the motor vehicle traveling the wrong way down Commerce Street. The law enforcement officer stated to the investigating officer that he observed red glossy eyes. The other law enforcement officer arrived on scene and observed bloodshot glossy eyes. The defendant admitted to drinking small margarita sample-sized drinks. The defendant stated she did not know she was traveling the wrong way down the street. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, and a 3 out of 4 on the one-leg stand. The defendant consented to a roadside preliminary breath test yielding a 0.12. The DIC was read, and the defendant agreed to provide a breath sample for the breath test strip reading a 0.086 and a 0.088.
Okay. Ms. Reyes, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you. If I find that you're using, I will put you in jail. You understand, man? Any prior DWIs?
No prior DWIs.
License?
Eligible.
Okay. You are not allowed to drive unless you have a valid license and insurance in your name. You understand? That is also a condition of your bond. I will appoint your lawyer today. So what we'll have you do now is I'm going to have you head on over to Victoria, sign a reset. We'll have you take a seat in the jury box. I'm going to get your bond conditions, we'll have you sign it, and we'll have you speak to a lawyer here momentarily, ma'am. Okay, please.
Next, Judge, is page 20, Taylor Marcus.
Aaron Smith, Aaron Jones Smith, come on up.
Taylor.
So, Michael,
Said he has a video.
who has to be? I know, but it looks like he's appointed to Jessica Taylor, who might be the co-defendant in this case.
It is a video.
Okay.
Yes, Your Honor.
Okay, well, I'll do yours after, I guess. So you are Marcus Taylor. Mr. Taylor, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 27th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a disturbance/unknown weapon call. the law enforcement officer met with the complaining witness who stated he is an employee of the state veterans home on the nursing staff.
John Garza.
The complaining witness states that the defendant is unwelcome at the facility and has been asked to leave on multiple occasions, and the defendant has refused to do so. The complaining witness stated the defendant was attempting to have his grandfather sign power of attorney paperwork. However, nurses intervened due to the grandfather being diagnosed with dementia. The complaining witness states that the defendant used force to remove the complaining witness from the grandfather's room by pushing the complaining witness on the chest with his hands. The complaining witness stated he felt pain. The complaining witness positively ID'd the defendant. Law enforcement officers detained the defendant without incident.
Okay. Mr. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go back to this location. Do you understand? If you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds. You were also ordered as a condition not to be in possession of any weapons as well. We are going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria Center recess. After that, we'll have you take your seat in the jury box while we get your bond conditions. We'll have you sign it. And after that, you'll be free to go.
This is affidavit, Judge.
Okay. Please. Okay, Michael, are you ready? Jessica Taylor, come up. You are on bond for murder, and you've now picked up an assault case. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Thank you, Your Honor. On April 27th, 2025, in Harris County, Texas, officers were dispatched to a disturbance/unknown weapon call. The complaining witness stated she is part of the nursing staff and that the defendant has been asked to leave on multiple occasions and refuses to do so. The complaining witness stated that the defendant was attempting to get her grandfather to sign over power of attorney to her, but the staff would not allow this due to the grandfather being diagnosed with dementia. The complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the defendant put her hands on the complaining witness's face and pushed it back. The defendant was positively identified by the complaining witness and her Texas ID number.
You say that there was any pain? She pushed in the face. This is an assault, right? There has to be some kind of injury or pain.
She did state that she felt pain in the dim summary.
Okay. Ms. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. Now, you're saying there's a bond violation in this case?
Yes, Judge, it's in the.
Michael, have you seen this? And how did you already get appointed to this case?
Your Honor, I was appointed sometime very recently on this case. I received a text. I don't know what day it was, but I received.
It looks like it was the 29th, which was Tuesday. But how was he appointed a lawyer?
I'm thinking when she was in the holdover.
No. How is she, I mean, I don't understand. Well, regardless, I guess I'm glad that you're appointed because right now she's got bond violations. She was ordered by the
magistrate. I wasn't aware of
magistrate.
that, Judge.
I'm sorry?
I wasn't aware of a BVR in this case. I actually have another BVR today before the court.
I know that, yeah, we got you. We'll deal with that one next, but you're on bond for murder. You were ordered by the magistrate to have a GPS monitor. You have violated those conditions. Unacceptable. I'm revoking your bond. She goes with you. No.
Your Honor, if I may.
Yeah.
Your Honor, She just was released because I met her in the holdover earlier this week, and she could not have been out of jail more than a day, two at the most. Would the court allow her to leave right now to get the device?
No. Did she not get the device?
There was a conflict, that's why the DVR was submitted, felony, so the magistrate ordered bond conditions, but the curfew times were not aligning with the felony condition.
So what? I mean, you still have to abide by the conditions. I mean, what did they say the conditions were?
I have the paper up right there.
I'm not asking you to say anything, Ms. Taylor. The only thing I want is I want my city protected. You're on bond for this serious case, and now you picked up an assault. I mean, you were ordered to have certain conditions. You must abide by these conditions.
And Your Honor,
She received conditions of bond on April 28th, 2025 that ordered a GPS device with a curfew of 7 p.m. to 7 a.m. On May 1st, she had an unapproved enter at 7:52 p.m. and then left again at 8:51 until basically 9 o'clock at night.
Yes, Judge, and on the felony conditions, I'm looking at them right now, their curfew is from 12 a.m. to 6 a.m. So that's where it's conflicting. So the magistrate ordered from 7 p.m. to 7 a.m. and on felony, their curfew was 12 a.m. to 6 a.m.
I mean, she still has to follow conditions, right? There may be conflicting, but you abide by the conditions and then you come to court and you ask to, do something or maybe make them align, but you just don't do whatever you want to do and think, okay, nothing's going to happen. You're on bond for 2 serious cases.
Your Honor, if I may again.
Sure.
This is a brand new case. Could the court admonish her? Because the amount of time, I understand that.
Michael, she's on bond for murder. She's lucky to even have a bond, and now she picks up an assault. She's ordered to have a curfew, and she's just doing whatever the hell she wants to do.
In this case, Judge, that's before your court. This is a brand new case, and this is her first time having any issues while on your bond, Judge. Would the court be willing to admonish her not to leave her home even for short periods of time?
I don't know, Mikey. I don't know.
And my assumption is we've reached out to felony. My assumption is there's a BDR call for that too. So I don't know what it looks like, but.
I don't know, Michael. I'm going to stew on it for a while. You want to talk about your other BVR? Or wait, hold on a second. Sorry, let me just finish with the arraignments. Give me 2 seconds and then we're almost done.
No problem, Judge.
Next one, Judge, is page 2. Avila, Diaz.
And do another bench you can come down to.
Judge, those on conditions, we want to do no returning to.
No. You don't need to do anything because I'm going to have her monitored like.
Yes, sir.
Yeah, we'll get to it in a second. Come up. You are Marvin Avila Diaz.
Yes, Marvin Avila Diaz. Yes, sir.
You were charged with assault of a family member. You are facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed for you, sir.
Thank you, Your Honor.
On April 26th, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. Officers met with the complaining witness who stated that the defendant and him are in a dating relationship. The complaining witness stated that they had just dropped friends off and started to argue about the vehicle they were driving. The argument became physical, and the defendant struck the complaining witness in the face with a closed fist multiple times, causing bleeding and pain. The officers observed the complaining witness to have dried blood on his face.
Que tenía sangre seca en la cara. Que estaba manejando, quiero saber el juez. No digas nada.
Let me take a closer look here,
Mr.
Judge.
Avila Diaz, I'm going to find that there's sufficient probable cause to go forward.
Ya hay
with the case.
bastantes motivos
Paint
fundados
was
para ir
alcohol
adelante con
or
el
anything a
caso.
factor.
Quieres saber si había alcohol.
I am ordering you now as a condition of your bond not to have any contact with the complaining witness in this case, not to be in possession of weapons. Mr. Avila, I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, it's very possible they put a detainer on you and you will be stuck in custody until this case is over with, and then you get shipped to immigration. Do you understand?
Contéstale al juez. Yes, sir.
Get no more warnings.
No,
Mr.
no.
Avila, I'm going to protect my city at all costs, and if that means putting you in jail, I'll do it in a moment's notice.
Judge, the law enforcement officer observed the defendant to be in the vehicle, but to be on the front right passenger side.
Pero estaba en el lado del
It
pasajero.
does not indicate that
No
alcohol was a
indica
factor.
que había alcohol como un factor finito. Nadie estaba
There is a protective order that has been issued in this case.
una orden de protección.
Get to know it. If you do something to violate this protective order, the state can and will probably file a violation of protective order against you. And that is one of the worst cases that you can make up.
Otro codazo feo que puedes agarrar. Entonces no hablas con él.
Are you working at this time?
¿Estás trabajando en este momento? No, sir.
Are you in school full
¿Estás
time?
estudiando? Ya terminé. I completed it.
It's time for you to do something. You need to either work full time or you need to be in school full time, but doing nothing, it's not going to work. That is also a condition of law. I will appoint you a lawyer today, but I'm going to bring you back in several weeks to see what you have done to get a full-time job. If it's nothing,
Voy a averiguar qué estás haciendo para conseguir.
do you understand?
¿Me entendió? Contéstele al juez.
I'm going to have you sign a receipt with Victoria. After that, I'm going to have you take a seat in the jury box while we create your bond conditions.
All right, Judge, the next Spanish arraignment is page 7, Hernandez. No, Enriquez. Rivera.
Oh, wait, hold on a second. Have you reached out to Mr. Zakes? Dude,
Oh, I didn't realize that.
take a seat. We're going to wait for your lawyer.
All right, that's the last Spanish arraignment, page 22, Yepes.
Yepes Ovidio, come up. Mr. Yepes Ovidio, you are charged with tampering with the government's record. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 26, 2024, a law enforcement officer was on patrol in Harris County, Texas, when he observed a motor vehicle going 82 miles per hour in a 65 mile per hour zone. A traffic stop was conducted. The law enforcement officer ran the plates and came back with no records. The defendant stated he did not speak English. The law enforcement officer discovered a case report was made on March 27, 2025 with the same vehicle in question displaying a paper plate, but with the matching VIN number of the vehicle, with no record shown on the vehicle.
Pero no tenía ningún récord tampoco.
A Spanish-speaking law enforcement officer was informed by the defendant that the defendant purchased the car 3 days ago on Facebook Marketplace and was given that paper dealer temporary tag. The defendant was questioned about the March 27th incident, to which the defendant admitted he was in possession of the vehicle during that incident as well. The defendant then admitted to operating a motor vehicle with a fake temporary tag on the vehicle. The defendant further informed the law enforcement officer that he purchased the plates off Facebook Marketplace and met up with a guy 3 days prior to the incident in a Walmart parking lot to receive the fake plates. The defendant was positively identified by his citizenship card from Peru and Venezuela.
License? Mr. Yepes Ovidio, I'm going to find that there's sufficient probable cause to go forward with your case. If you do not have a Texas driver license and liability insurance, you are not allowed to drive, and that is a condition of your bond. If I find that you violate these conditions, I will put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail, immigration finds you because they sweep it hourly. They will put a detainer on you and you will be stuck like Chuck in there until this case is over with, and then you get shipped off to immigration. Do you understand?
Judge, there's no driver's license information populating for the.
This is an affidavit. This is a promise you're going to make to me that you're not going to drive. I don't care what your excuse is. I don't care what your justification is. If you drive, it's really not going to go well for you. Do you understand? Okay. We're gonna have you come up here to swear to us that you're not gonna drive. After that, I'll have you take a seat in the jury box or with all conditions ready. Have you sign it. Dick, anyone else?
Council was here for this morning to do a plea. Want to do that?
Yes, may I approach on this?
All right, come on.
Page 13.
Good morning, Your Honor.
Good morning, Mr. Blaine. How are you?
I'm doing well. How are you, sir?
Ready.
Thank goodness. Yes, Your Honor. No, Your Honor, speak up loud enough for me to hear
Good
you.
morning, Mr. Melcher. You're charged with driving while intoxicated. You have worked out an agreement. They're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that after today, this charge will go on your record. It's going to be there for the rest of your life. If you ever get pulled over, which is going to happen, an officer is going to look up your record. If they see that you have a prior DWI and they roll up to your window and they smell alcohol or dope, it's probably not going to go well for you. What we're doing today, from now on, it's a minimum of 30 days in jail. Not to mention a $6,000 supervisory fee. And if you don't pay it, every $100 you owe, you sit 1 day in jail. Understand?
Yes, sir.
You're giving up the right to a trial, the right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, there's no turning back. This is what you want to do. How do you plead to the offense of driving while intoxicated? Guilty or not guilty? I'm going to find you guilty. I'm going to sentence you to 3 days in jail. I'll give you credit for the 1 day that you've done. I'm going to suspend your license for 180 days, sir. Do not drive until you get a license. Good luck to you.
Thank you, Judge. Maybe we need keys.
Mr. Clay, does he work? What do you do for a living, sir? What kind of money do you make a month?
It makes about $1,400 a month. I've had the conversation with him. He has about $200 left over at the end of the month.
There's a $3,000 fee that would normally apply. I'm going to waive it for you now, but you pick up another one, get ready. It's a $6,000 fee. Do you understand? All right.
Thank you. Thank you, Judge.
All right, Mr. Clay. Come on.
Judge?
Yeah.
Judge, I've got 4 new fugitive appointments today.
Okay.
You want to start day with?
Yeah, so there's going to be 2, Judge, where I'm going to be entering a pre-signed waiver. It's going to be for Bushnell and for Deruin.
Okay.
And I went ahead and gave, hold on. Okay. Yep. Right.
Bushnell, and what was the other one?
And Deruin, Tara Deruin. I don't know if I'm pronouncing that accurately, but I just,
It's about the next 2.
and then Johnson, hold on.
So Tiffany Johnson, Judge, she would like a bond. She's wanted for larceny out of Louisiana.
We'll have to talk to her. I mean, so I would bring her out and then, if you want both of them out, let's do them both or did you, the other one as well?
The other one, Judge, Yolanda Swift is currently in medical, so we're just gonna keep her waiver for now and roll her to next week.
Okay, yeah, for sure. Okay, Lori, you ready? Holman, come up.
No, he's in jail, Judge.
Oh, she's in jail. Oh. What do you want to do?
You just need to revoke the, I guess, raise the bonds, or she's on bond on the new evading case.
Yeah, okay. I'll whatever you want, Lori, you know?
All right, I'll just reset her to next week.
Okay, you got it.
Thank
So what day you want?
The 8th.
You hear that, Vic?
On who?
Holman.
Yes.
Yeah, okay, you're good. You, okay. All right, Maria, you ready? Yes, ma'am. Good morning.
Judge, I'm approaching on Victor Jesus Rauda Lopez. And he's got a bond violation reported on him.
Page 10.
Is he here?
He's here, Judge. He's in the jury box.
Speak English?
Yes, he does.
Come up. Come up.
Answer yes or no, sir.
Did you get your GPS device?
Oh, yeah.
Okay. I'm revoking your bond. I ordered you to get a GPS device. You didn't get it. Okay, those with you. Sorry, Maria. All right. We're going to keep you. The bond right now is, oh God, it's 5,000 now.
I already paid the half.
1,001. We'll just raise it up 1,001.
6,000.
It's 5,000 now.
Right.
So I'll just do 6,001.
Okay, Judge. 6,000.
So if he bonds out,
Yes, Judge.
we'll get it.
Oh, Judge, I have, I was assigned a new case
Okay.
because I was appointed about 2.5 weeks ago to 3 previous cases that he's got. And my client is in custody. He's got an immigration hold. He does not have any bond set.
What's the last name?
Manuel Coc Cooch, C-O-C-C-U-Z. And he's got 2 felonies pending, Judge.
Just file this while he's in custody?
Sure.
File this while he's in custody?
Yes. Yes.
So it looks like they found, that's so weird. They found probable cause on it, but they didn't put a bond on it. Right? No, it's weird. I'll set it at, the other ones are at 10,004. I guess I'll just match those.
Yes, Judge.
You know, it really doesn't matter because he's not made bond on the felony or any of the other cases. So
He's
just,
got an immigration hold, Judge.
so we'll just set it at the
I'll
same.
get a reset, Judge. Thank you.
So 10,004, what the other ones are set at?
Reapproach, Judge?
Yeah.
This is on the Tiffany Judge.
Johnson, you said, right?
Yes, Judge.
All right, good morning, Ms. Johnson. So it looks like you are wanted out of the state of Louisiana for a larceny. It's a misdemeanor, am I right?
Yes, Your Honor.
Okay. Your lawyer's asking for me to set you a bond. I don't know. I need to know more about you. My primary concern, number one, are you going to go back to Louisiana if we give you a bond? Number two, are you going to leave a wake of destruction? Because that's what we don't want. We don't want you to be danger if you're danger, you know. Well, I know that you're going to tell me it's little bunnies jumping in the woods. Everybody does, right? But how you look on paper really tells me who you are.
Your Honor, the demanding jurisdiction requested no bond because the demanding jurisdiction showed that she is also wanted for failure to appear for a DWI, and the FTA was issued out from Caddo Parish on July 21st, 2022, but then she picked up this larceny within the last couple of months this year. While that was an FTA, state requests that there's sufficient bail be set for the fugitive to be returned to their demanding jurisdiction. State requests a $10,000 bond because of the fact that it's a 3-year-old FTA. On top,
This case is 3 years old.
no. The other
The DWI.
pending, right? She also is wanted for a DWI out of the same parish, but this specific fugitive case is for the larceny. I'm just highlighting the reasons for the higher bail. It's because the older case was 3 years.
See what I mean? That's what I'm saying, you know? Yeah, I know what you're going to tell me, but paper tells me another thing. And that's a big problem. The DWI has been open for 3 years. Now, the only reason we have you is so are you okay with the bond then?
Okay, with a bond, just a sufficient bond that she return herself around.
Okay.
Yes.
Judge, we wouldn't be opposed to 10,000 if you could set it at that.
Okay, I want you to understand that I don't play games. I'm not going to do this repeatedly. I can set you a bond now, but if you don't go, I'm going to revoke this bond. I will set it at 0. And this time I'm going to hold you until Louisiana comes and gets you. And we're not going to do this again. You have one chance to make it right. We give you 2 weeks from the date of your release to go turn yourself into Louisiana. You must turn yourself in, not, I'm going to go do this. I'm going to hire a lawyer. I'm going to try to get a bond. No.
Just go turn us.
Go turn yourself in. The other thing I'm going to tell you is that Murphy's Law, you know, what can happen will happen. Don't wait until the last day. You know what? I'm going to go turn myself in now. I don't care if you car trouble, abducted by aliens, don't matter. As soon as you get out, I would go because that's a lot of money that someone else is toning up for you to get out. Do you understand? All right.
So I just wanted to highlight, and obviously the court set the bond. I'm not disputing that, but just because there have been 2 other fugitives from Caddo Parish that have waived, and I have 6 total from Louisiana. I imagine the transport is going to be soon. So regarding financial capabilities on restoring the bond when returned to Louisiana.
So let them know, you know, what he's trying to tell you basically is that because Louisiana, we have so many people in our jails from Louisiana, we have buses coming 1 to 2 times a week to shuffle in people from and to Louisiana. So if you were to waive within the next couple of days, they'll probably have you back in Louisiana as opposed to someone dropping 10,000. You said 10,000?
Marcus Taylor. So yes.
As opposed to someone dropping 10,000 to get you out to go turn yourself in within the next 2 weeks. It's up to you. I'm just letting you know what it is, and then you guys can decide what you want to do. Has she waived already?
She's waived. That's why I can stand down if you want to talk to her.
Once, because you have already waived, so we give them a certain amount of time to come pick you up. If they don't come get you within that time, we release you. Once, if you want to post bond, you have to withdraw that waiver and you lose all the time that you've accrued toward that. I'll let it explain to you, and you guys tell me what you want to do.
Yes, Judge. Okay. All right. And Judge, I guess we need to have Bushnell and DeRoyan brought out as well for their pre-signed waivers.
Just enter in the pre-signed waivers. Unless you don't want them to come out to enter, then
I don't care. Just have them sign it and get it. Yeah.
Well, they don't really need to sign, pre-sign.
And just explain to them if they have a problem or if they don't believe you or they're giving you a hard time, just let me know. No problem.
Okay. Thank you, Judge.
Okay, Ms. Hall.
Your Honor.
Hey,
All right, here we go.
thanks. Did you get it done? Tell me you did.
I needed to speak. Pretrial needs an order for you to sign. They're going to put it in the queue so I can get it off to Genetech in Sarasota, Florida. They're requiring that for me to set an appointment. That's why.
Genetech.
Sorry. Quest Diagnostics, Genetech. I'm sorry. That's another place I'm having a problem with. It was something yesterday.
Okay, I'll send it.
He can set it up, the appointment immediately as soon as I get that fax to them.
I'll give it to you now.
And Judge, because client is not here,
Right. You have to waive it.
Thank you.
Yeah, waive the second.
Thank you, Judge.
Did you put it in the queue already or no, Roxanne?
no, I'm.
She needed a nail tag, Judge.
You ready?
Hi, good morning, Judge. How are you? I'm
Happy Friday.
approaching off docket on the trial case,
Okay.
and the cause number is 2545831. And the state has filed dismissal, Judge. I was just approaching on it.
Okay, I'll sign it.
Okay, thank you. Good seeing you, Judge.
Morning, ma'am. Approach.
Morning.
So I'm here on Mitchell Estrada. Gary Tabachman said he spoke to you yesterday on the
Yeah.
phone.
Do you have the cause number?
No, Bob number in Harris County.
No, but for the other case in
No,
court.
it's, their temporary case number, some of this.
I know, but the cause number for the court 11 case, because that'll help us pull it up.
Spin.
But that'll work too. What is this?
I have to spend it. 030-604-31. I'm glad Gary spoke to you because he told me.
Blaze, I need your help real quick.
Absolutely.
Can I give you a call? Oh, she pled already?
Not that I'm aware of. On what case are you looking?
Is it Mitchell Estrada?
Yes.
Oh, I thought she had an open DWI. She only has these two out of county.
Two in Lee County. She has no cases here.
Okay. Can I give you a cause number?
Is this Michelle Estrada?
Mitchell, yeah.
Yes, I see that.
So she has two out of county cases from Lee County. They're asking for a bond to be set so that she can bond out and go back to Lee County. Because otherwise, essentially, whenever you get picked up in Harris County for a case that's out of county, Harris County holds you here for 10 days. And at that point, if the out of county doesn't come get you, I give them a PR bond.
Is there not a, so that's what I guess my confusion is.
She's been in custody. The hold was placed on the 29th, so she must have been arrested here this past Tuesday. And at that point, Harris County told Lee County, hey, we got your person. So Lee County puts the hold.
I'm trying to figure out, so we don't have any charges. Correct.
You do not.
Yeah, it looks like she got taken out Class Cs. I mean, that's however you do it, Judge. What do you mean?
She has a bail jumping, and I wanted to just run it by you guys and see. One is a bail jumping and another one is a PCS 1 to 4.
Can I talk to David real quick? I think it's also like. Yeah.
I've not, probably in the entire time I've had this, we've only had this one other time where it's been an issue like this, where we've had someone come and ask for a bond on an out of county case. So I want to make sure that, I guess, everybody involved is.
Understand. It was really, I got a text this morning. Is anyone in state court? I said, yes, I am.
I mean, I'm not, do we have her?
No, because it's a temporary case number. It's not even a court filing.
The thing is that we're not going to get her here until the 10th day pops up. So she's basically just sitting in a holding cell in 1200 Baker until. So what happens if we set you a bond now, you have to go let her know that the bond has been set. She has to make it as soon as she gets out. She has to go turn herself in Lee County. Because otherwise she's just not going to know. They want a bond set so she doesn't sit there for the next 10 days or 8 days.
But the issue with this one, and this is largely outside of the DA's office role in the out of county. For this
No, but I wanted to still be,
I know, but the issue with this one is equivalent to whenever I request the interstate compact agreement to be entered, is we're largely divorced from that proceeding, and the hold is placed with the sheriff's office. So they communicate with the demanding jurisdiction. If anything's going to happen, it's going to be with their jurisdiction and our sheriff's office. So for the most part, there's no active matter in this court to be contested directly. And like, there's nothing that can be.
Set her a bond.
But there's no case to set up on too. That's my point, is right now there's nothing filed. There's no case number to enter in filings for. So it's like the interstate compact agreement. If somebody asks to.
Do you hear that? So there's no.
Because sometimes they do create a case. That does happen. I've seen it before. You've seen it before.
Basically what he's saying is until the 10th day, no case numbers created for me to attach a bond to.
No cause number that's not.
Right, so
attached to bond.
there's nothing to be filed because there's nothing to be entered into, so it's filing documents for a case that doesn't exist. For the hold itself, there's numerous reasons the hold can be created without a case being created, and this is just one of those administrative mechanisms that happen between.
There has to be a way that we can give
Sure,
a bond or a
but-
PR bond or
but-
some way to release.
Right, but typically, and this is largely where I have to kind of take a step back, but if it's the demanding county that's wanting them, that's where the conversation should be, because they're the ones that want.
Have you reached out to Lee County yet? And I forgot to ask this Gary yesterday.
I was just told to come by about an hour ago.
Because it'd be the equivalent of if there's an out-of-state jurisdiction that withdraws their hold or their warrant, is I would ultimately
Is there a
dismiss
way
the
that I
case.
can put bond with you?
On a temporary case?
Do me this. Give me a second. Let me reach out to admin to see what more we can do.
Oh, in terms of if the clerk's office, if not, the one, and that's again.
Yeah, can you give me, let me kind of thin it out a little bit, help the lawyers that are waiting. And then, because it's going to take more time for me to reach out to admin to see what I can do.
I'll hang out.
Yeah, just give me, and I'm sorry that you have to wait. Do you want to go, leave me your cell phone, and then I can text you so you don't have to wait, and then you can always Zoom? So we don't have to just sit and wait?
Do that.
Yeah.
Sorry.
I mean, I'm going to try as much as I can.
No, I appreciate it.
You know?
I appreciate it. I'll get that. Morning, Judge.
Stephen Davis.
We
We're on a PR bond on this case, Judge.
Okay.
He had a arraignment date maybe a month or so ago, I believe. He had missed his court date. You had given a
Morning, Mr. Davis.
$1,000 bond.
How's jail?
not good.
Right, it's not supposed to be.
Right.
Problem is when you don't show up, this is what happens, right? And when you repeatedly don't show up, therein lies an even bigger problem, because I know if I give you a PR bond, what's going to happen? History dictates. And therein lies the problem, because we give everyone, well, not everyone, but nearly everyone, a PR bond.
Yes.
But you got to show up. How many times has he failed to appear?
I believe it's just one time from my understanding.
No.
And so part of the
He
reason.
was first given a general order bond in March, failed to appear for his arraignment. Then he gets rearrested. We give him a PR bond in April, and then again, fails to appear again. And that's why we have him. So it's been 2 times.
Friday, you will bring this from the Friday.
And Judge, part of the reason why I'm asking for a PR bond, I've talked to the state. He does have some mental health diagnosis, history. He is bipolar, schizophrenia. They have agreed to allow him to go to Harris Center